time, and that's how you're going to do
So just so I can be clear, because we're going to provide the court with the affidavit. That's not an issue. The question becomes is, should the court say, no, we're not turning over the affidavit, but we're taking the deposition of Detective Luna, which concerns materials contained in an affidavit. If the court's not ordering it turned over, in the state's view, she can still refuse to answer those questions because it will go to that ongoing investigation.
I'm sorry. I understand what your position is. Listen, who decided to charge him with Tampa? Who did that?
The 23?
Did they do that?
Yes. No, I mean, no, but I understand where the court's going.
Law enforcement did that, right?
Yes.
The state did that.
Yes.
Okay. So you all decided, for someone who's already facing capital charges, let's open up a new case. Let's charge him with a new crime, which could land him in prison for the rest of his life. So you're confined to the rules of discovery. I don't know what to tell you. You could have done all this the day after his murder trial was over. You could have done all this. You know, he chose to do it when he chose to do it. So be it.
No, not the 20. So the court's clear, for the record. The 23 case has nothing to do with this Apple iFile affidavit or with what Detective Luna potentially testified to in terms of her work in this new investigation. They have nothing to do with each other.
Sir, if a law enforcement officer hypothetically showed up at my door asking to service a search warrant on anything that belongs to any lawyer who's currently litigating a death penalty case, I would decline that request and probably ask them to leave the court. Okay, so that's just my view.
Thank you.
So those are the orders as to that. Okay? So I guess I'll get it, I'll look at it, and I'll enter a separate order as I did in January based on what I read. Yes, sir. Last one. I have the state's motion to reconsider or order moving forward with the trial on September the 10th. Its trial date remains set on September the 10th. We did that last July 8th, 2024, although there's no motion to continue filed. I did read the motion. I guess I'll treat this as a motion to continue. I did read the authority cited therein. I did read again, Florida Statute 924-071. Additional grounds for appeal by state, time for taking and stay of cause. I likewise again reviewed the omnibus order on defendant's motion to suppress 1 through 13, which was entered by Judge Murphy on December the 20th, 2023. I also reviewed the order from Judge Murphy denying the defendant's motion to set aside stay, an order granting the defendant's motion to modify the stay to allow discovery to proceed. That's entered May 2nd, 2024. I likewise reviewed a Florida Supreme Court case called Mitchell v. State, 911, 7-2nd, 1211. Supreme Court case, September 2005, regarding serious constitutional issues that are implicated if the state were to be automatically entitled to stay the effect of the decision adverse to the state in a criminal pursuit. So, understanding that I've already looked at all of that, state, anything else that you would want to tell me in support of your motion?
No, Judge. My motion basically covers the previous court's orders, the statute, case law in terms of how this case is stayed.
Okay. Defense, you all want the case to be stayed? The state says it stays, so do you agree with their motion, or do you not agree with it?
Can we have one moment?
Sure. sir.
Against our advice, our client wants to proceed.
You object to their request for me to determine if it's automatic stay.
Based upon what our client has instructed us, yes, sir.
Okay, so let me make the record crystal clear on this one issue. I am aware that 924-071 calls for an automatic stay while the state is appealing some order that they want to appeal. In this particular case, and this again, this is so I cannot state it. Judge Murphy entered this motion to suppress, which is the subject of the appeal. He entered this order on December 20th, 2023. That was 558 days. And in that order, he says at the end, the court has not been moved to consider the suppression of specific evidence. It is up to the parties to inform the court as to what specific evidence falls within the suppression order and what specific evidence is admissible pursuant to that order. When we were here on the defendant's renewed motion for bond on May 6th, that was 65 days. I asked you all, had you gotten together and figured out what specific evidence falls within the suppression order? I'm going to guess that hasn't happened.
No, Judge, I made the proffers of the court last time as to what that evidence would be.
It was basically penalty phase, for lack of a better term.
No, they were aggravators. They go to membership in a gang. There are things that the jury would have to find before going into penalty.
Not aggravated us to death, but
Sorry.
aggravated us to gang against himself. That was charged. He was charged in committing the murder for the further to the gang, which is an aggravator in terms of the guilt.
Something that they would have to find by way of an interrogatory.
Yes.
Yes.
Objection, that's not
Correct. You all don't agree on it.
No, we don't.
No, what you just said, we do not agree on. Here is,
I'm sorry. Have you all done what Judge Murphy ordered you to do in 2023? It is up to the parties to inform the court as to what specific evidence falls within the suppression order and what specific evidence is admissible pursuant to this order.
Now, may I answer the question this way? At that time, the state appealed it all, which stayed everything. And so, at this point, the law on whether or not Judge Murphy was right or not is all up at the court, and it stayed. We can't determine that in a stayed case. It stayed.
You can't talk to the state and decide what this applies to.
I just argued what I have to argue, Judge. You're saying it stayed for only one purpose,
I want you to
but
answer my
not.
question.
The answer is we are stayed and unable to do so.
You don't even know what evidence the order is.
No, I believe we do, and I think that's on appeal at the court. But during a stayed case, we cannot do those things. And that's why it hasn't been done. Not because we haven't wanted to. They appealed it. It stayed.
Unfortunately, to also remind the court, the defense did cross appeal, so even stuff that would remain in is also potentially could now be excluded should the court rule the defendant's guilty.
And that's still pending before the court.
But you don't agree with their request, you want to go forward. That's what you just told me, your client wants to go forward.
That's what he said.
So just to, if I can clarify something, our position. The order that Judge Murphy entered kind of does not make sense. No offense to Judge Murphy, I loved his rulings. But the order doesn't make sense because he did not suppress evidence. He suppressed evidence based upon a time frame. So everything before a certain date and everything after a certain date was suppressed. So I do not even understand how we could comply with that part of the order because it's everything between those dates.
You can sit down with the state and make up a list, do everything that's out.
Happy to do so, take just 5
Well,
minutes. It would take more than 5 minutes, but it can be done easily.
Well, again, and Judge Murphy did this a lot longer than me, but that's what he ordered you to do, 568 weeks.
Which,
That's what he ordered you to do. He didn't ask you to do it, he ordered you.
fair enough.
And I brought that up 2 months ago. Has anyone bothered to do this? And your colleagues tell me he can't even do that. He's not allowed.
Well, I just want
You
to
do it?
What I'm pointing out to the court is, it is just a time frame. It's not an individual piece of
Yeah,
evidence.
I understand that. In the typical motion to suppress, we're gonna suppress the firearm that was found in the
Correct.
trunk of the car, or we're gonna suppress the statement from the defendant, and usually at the end of an order granting a motion to suppress, it says, here is the evidence to suppress. But he didn't do that.
And I'll
And I
tell
don't
you,
have the benefit of sitting next to him when he went through all of this, so that's why he ordered you all to
and all
say
we
what
would
it
do,
is.
and all we would be doing is reciting his order. Quite candidly,
Who's arguing at the court? This relates up to who's arguing? So what if their first question is, what evidence have we found?
everything from this date to that date.
What date is it?
I will have that.
It's not in this.
This
Am
is-
I, remember,
It's in the
I'm not
order.
making this up. It's in the order, Judge.
It's in the order.
There are timeframes in the order. I was able to
I know, but I
determine.
don't know what all the evidence is. I don't know what all the exhibits are. How would I know that?
That is,
You all know that. I don't know that.
that is part of the problem that we haven't even gotten to some of the motions. When we're talking about over 2 million Instagram lines, nothing is delineated that I am suppressing line 1,287,000. All we have is a time frame, and everything within that time frame is suppressed, not anything specific. I don't know what the state's trying to introduce.
Through the dates, I have a general idea of what the messages are. I can theoretically sit down with the each device, each return. I can plug in the dates, and it'll be like, okay, it's these 8 messages, it's these 6 messages, it's this Instagram account.
That's the only thing that was suppressed.
Essentially, yes. There's messages from Snapchat, from Instagram, from other accounts. Is some other stuff I'm trying to recall.
Judge, I have a pending motion that's been pending now for well over a year, probably over 2 years now, or we're approaching that. And that is for the state to delineate what they are intending on using, because if they have 2 million lines of Instagram messages, we can't be prepared for that. Are they introducing all 2 million? Are they introducing just some? And Ms. Buckaloo has said to me on numerous occasions, let's not hear that motion. We're not ready for it yet because we don't know exactly what we're trying to introduce. So we have not had that heard. So I do not know what specific line the state wants to introduce that would be suppressed by that order because they have not told us. So all I am left with is that sole period of time. I have nothing else I can say. I can say every Instagram from such and such a date to this date because I do not know what they're intending on using.
Okay, so, in Judge Murphy's order that denied the defense motion, quoted numerous Florida cases, quoted from. Although a trial court may vacate an automatic stay during the pendency of an appeal, it may do so only under the most compelling circumstances. Party moving to vacate an automatic stay must demonstrate that the equities are overwhelmingly tilted against maintaining the stay. In determining whether to vacate an automatic stay, the trial court must consider the government's likelihood of success on appeal and the likelihood of irreparable harm if the automatic stay is reinstated. I'm also going to quote Mitchell, which was a Jimmy Rice case. That's from the Florida Supreme Court. Ordinarily, there are 2 principal considerations that courts must take into account when deciding whether to vacate a stay. The likelihood of irreparable harm if the stay is not granted, and the likelihood of success on the merits by the entity seeking to maintain the stay. That's the state. These stays are subject to the discretion of the trial court to dissolve or modify based upon the important interests of the parties and the particular circumstances of each case. Lastly, and I think I'm repeating myself in the hearing today, they recognize a special exemption in criminal cases. This exemption is directly related to the serious constitutional issues that would be implicated if the state were to be automatically entitled to stay the effect of a decision adverse to the state in criminal proceedings. I'm only supposed to vacate these stories, which the case law says I have the authority to do under the most compelling of circumstances. I do find this case to be under the most compelling of circumstances. Mr. Chairman, as I sit here today, I've been in custody for 2,339. I specially set his case for trial on September the 10th. I did that back on July 8th, 2024. Over a year, 367 days. This division that I took over from Judge Murphy, FT, the trial division, was created specifically for the purpose of trying long jury trials for people that were in custody for a long period of time, to prevent exactly what has happened to Mr. Devin from happening. Besides Mr. Devin's cases, which I've removed, this division currently has 38 other cases, special set for trial. 22 of those are murder cases. Numerous of those are death penalty cases. And right now, this division has trial special set for December of 2026. Which means any new trial dates I give out will be starting in 2026. I have reserved the entire balance of September and the entire month of October to try Mr. Devin's case, Mr. Henry's case. So if the defense doesn't object over the state's objection, we are going to go forward on September 10th. The state's motion to reconsider oral order moving forward with the September 10th, 2025 trial date is going to be denied. I will enter the appropriate written order. Next, I'm starting a capital case tomorrow. The only thing that's going to interfere with the September 10th date is if we have to redeem the penalty proceedings in that case. I don't know if that's going to happen. But what I can tell both parties, and you all can write these dates down, I'm going to give you every available day, every available minute that I have between now and September the 10th. To do whatever it is you decide if I can. On Monday, August the 18th, I have from 9 o'clock to 12:30 and from 1:45 to 5 o'clock. That's the entire day. To the normal 12:30 to 1:45 minutes. On Tuesday, August the 19th, I have from 9 o'clock in the morning to 12 noon.
What was the hours of the 18th? I'm sorry.
9 o'clock to 12:30 and 1:45 to 5 o'clock. The next day, which is Tuesday, August 19th, I have 9 o'clock to 12 noon. Again, the only thing that would interfere with those is if I happen to be in a penalty proceeding in the trial that's starting. I then have September the 5th from 9 o'clock to 12:30 and 1:45 to 5 o'clock the entire day. Tuesday, September the 9th, from 9 o'clock to 12:30. So the grand total of those dates and times that I just told you is 20 hours. I'm not going to set anything else. I'm going to leave those 20 hours available to the party. You may use them as you see fit, or you may not use them at all. I don't know what else to do. Except make myself available. I'll tell you that we're going to start screening jurors for dates. Wednesdays.
And I apologize, Your Honor. I have the 8/18 and 8/19. I missed the other dates. I was
September the 5th, that's a Friday. 9 o'clock to 12:30 and 1:45 to 5 o'clock is September the 9th. That's a Tuesday. 9 o'clock to 12.
if I can, just for purposes of the record, because I know the court has cited that the defendant had been in custody for a long period of time. Just to bring, for the record and for the court's attention, the defendant has already had one completed jury trial during this time period, which was a mistrial. A second trial was started, and a continuance was taken during jury selection because of the difficulties we were having with seating a jury in that case. So he has had those opportunities for trial. In addition, the state did take an appeal. The defense also did take a cross appeal. So when the court talks about the overwhelming issue and compelling the state to go forward, I don't know if the court is considering the fact that the defense, by filing its own cross appeal, has also created a delay. And if he's insisting on going to trial, is he now waiving that appeal, seeking a suppression of additional evidence? And finally, Judge, just so, again, the record's clear, what this, given Judge Murphy's order, and there would be an intent to comply with it, what the court is compelling the state to do is to go forward with evidence that has been suppressed. In other words, we would not be able to use that evidence.
You can't. Right. It's suppressed. That's exactly correct. Listen, I have file orders from a higher court. Well, it's plenty of time, from what I've told you right now. If someone
Yes.
goes up to the Fort BCA and asks them for a stay, and they send me an order that says it's stay, I'll give all these stays. And you have to figure all that out in West Palm Beach.
And that's a conversation we'll be having, Judge. With the court's indulgence, just one other issue, going back to the order compelling Detective Luna to testify, answer questions. What we would ask the court to do is just briefly, in camera, with the court reporter, just take brief testimony that it is an open investigation. We just need that clarity so that when we discuss it with the AG, since it'll be testimony as opposed to my proffer. I understand.
I mean, if you don't like what happened in court, you change it. I mean, you all have an ethical obligation of the court.
For a testimony as it relates to his homicide case, but they're going to go into another area, and that's where we'd be seeking that protection with the in-camera review of the open investigation.
How do you know?
Well, they proffered some of them, and I understand what it's like to be a defense attorney. I kind of know where they're going to go, Judge.
Okay, that request respectfully is denied. Anything else?
So, or just clarity, you're refusing an in-camera hearing for the fact that it's an open investigation.
You want me to bring a witness, what, in the jury room, outside of the presence of the public?
Yes.
With the court
With
reporter.
with a court reporter. With a court reporter. This is the guidelines that are outlined under Rule 3220. The court so the court is aware to create a record that there's an open investigation. Because I want that clarity for the court when they ask, is it
I don't
initial?
believe that there is. What they argue is correct. I said that in January. Back when I was doing this, standing out there, it didn't take PSO 18 months to arrest my client. It took about 18 minutes. So
I can show you the investigation. But I have a different opinion. And that's the point of why I'm asking, just for purposes of record.
how long would that last? Now, I'm not going to argue. You're telling me this could be ad infinitum. This could be for any indefinite period of
I can
time.
discuss that with the court in camera, how long the investigation is going to take, but I'm not prepared to do it in front of.
So, but law enforcement gets to decide that. That's your position. They just get to decide.
Well, it's also dictated by when and how evidence is received, where it leads, how long it takes to get that information, how long it takes to interview those witnesses, et cetera, et cetera.
They've got to take homicide detectives every 2 months. Okay. Anyway. Are you kidding me? You could circumvent the globe in 18 months and collect evidence from anywhere you want. That request is, I mean, you didn't file a motion. You're making this a moral. I guess if you want to have.
Well, no, it was part of my original motion to have an in-camera hearing. That was in my motion. That was in there.
That was part of your response.
Yes.
His motion.
Yes, that we were requesting the in-camera hearing. If the
So you
court,
already did it, right. So, yeah, your request for an in-camera hearing is respected. She's a witness. I don't know any sense of it. She's a witness. You listed her as a witness, right?
About 20 minutes ago, Your Honor, the court filed.
Okay, well, who did it when we started the case? Who listed her as an, I mean, you want to do it this way? Who listed her as an witness? They didn't, right?
I don't know who I
Well, somebody did. Right?
Yes.
Someone from the state attorney's office signed their name and said, this person has personal knowledge about this case, right?
Yes.
Okay. So the rules are the same here in any other circuit or county court. Your request is denied. I'll stand on the reasons why. State, anything else I can do for you today? One moment.
He need not scrunch up his face like that.
They asked for a moment.
Oh, I'm sorry. We're trying to make sure the record.
Defense, anything else I can do for you to say?
You can dismiss the charges against them, but I don't think you go.
You want to do that? Anything else?
No.
No, sir. Okay, so as of right now, Mr. Jemmons does have a court date, I know this next week on the tampering case and the status date. We want to just handle that right now, but you're going to hear right now. All right, so this is in 23-1-0593 CF10A. Mr. Demings as well as Mr. Henry as well as Mr. Mathis are set for status, what we call the calendar call or status of trial next Wednesday, July 16th. So I'll handle Mr. Demings' hearing right now.
I can cover for Mr. McGrattan.
I think he filed
You
his
know, by
interview
Zoom,
soon
he's
next
on
week.
Yes,
I don't wanna,
I just spoke to Mr.
All right,
Haddad.
so listen,
Okay.
Ms. Liberty, I also have this case set for trial September the 10th, the same day, obviously, it's set for trial, but anything else we need to go regarding the camera?
So in light of the court's ruling on the homicide, I would just oratously renew my motion to lift the stay so we can argue the C4 motion, Judge.
I'm going forward, I'm ready to argue here anything you want, anytime you want.
Okay, so I'll set the C4 motion for one of those dates that you gave then, Judge. Thank you.
Sounds like a good idea.
Great.
So Ms. Wilcox, you can believe Mr. Demings on July 16th. He remains set for trial in that case. The case is now adopted to the 23-10594 CFNA. He remains set for trial September the 10th. The judge is
for the record, I know what the court's ruling is. For the record, state raises the same issue in its motion. It's automatically stayed. Judge Murphy also entered a stay. In the case, it's the same evidence that has actually been suppressed that we were intending to use in the tampering case. So same arguments that I made on the 19 case in terms of how the stay should remain in place. The automatic stay should not be listed. The state would be compelled to go to trial with evidence that had, or without the evidence that had been suppressed. And we're asking the state to remain in place. Or the state is automatic, it should remain in place.
Yes, over your objection. The city ruling that case is well for the same from Kevin Davis, that I've already thrown the record in 19-1872 CF. Your objection to
Thank you.
state, you need the affidavit.
We're going to talk to the AG, Your Honor, but once we make that determination, we'll either advise the court as to what's going on, or we'll turn it over.
Judge, will you give them a time limit?
You said 5 days.
5 days.
Yeah, you said 5 days.
I didn't hear. Thank you.
Okay.
Thank you, Your Honor.
Thank you.
Okay.
Have a good day.
Ms. Wilcox is otherwise concluded. Okay. So that these otherwise will be in recess until tomorrow, which is Thursday, July the 10th, at 8:45 a.m. All right. Again.
All right, y'all.
Good side. Of course I do.
Everybody out, do whatever they out, do it. There's two of them.
All right, a few things happen. So I know this getting ready to pop off. So I will stop this share and get the folks up to speed. So today they heard the motion for rehearing for bond, and that was denied. We did miss a bit of that, but essentially that piece was denied. The motion to compel Detective Luna to basically be deposed for her to answer those questions was granted. He also granted the motion for them to compel the affidavit. He said that they got 5 days to turn the affidavit over. The request to have the affidavit review in camera was denied. The motion to stay the trial was denied. Judge Fine said that Melly been in jail for 2,339 days. He says that rules are in place to prevent what's happening to Mr. Demings. His calendar is actually booked out through 2026, which means if he had to postpone the trial, Melly wouldn't get a trial date until 2027, which I think, like Jenny said, the state is really trying to stall to get that time. They also tried to shift the blame onto the defense, saying, well, yeah, we filed an appeal, but they also filed one too. I mean, come on now. But nonetheless, he said that they got 5 days to turn it over. He's not changing the court date. They asked Melly what he wanted to do, and against his attorney's advice, Melly said, let's go. Okay, Melly was right. Matter of fact, Melly was back there cussing motherfuckers out. I was reading his lips. He was cussing them out like, I don't give a fuck what you talking about, nigga. Come on, like let's go. You can see that. So Judge Fine said, look, we gonna have trial September the 10th. I got 20 available hours on my calendar, and y'all need to use them as y'all see fit. Meaning, whatever motion you need me to hear, whatever we need to do outside of the jury, we need to go ahead and do that before September the 10th, because we are going to have trial. Now, it sounds like the prosecutors are going to be meeting with the attorney general, and probably other folks, to try and get the trial stayed. In that case, I don't know if Judge Fine will actually attempt to grant him a bond or not. I think that would be the time for her to file another motion, because 2027 before you can have another court date is ridiculous. It's ridiculous. But that's really what happened right there, y'all. So thank you everybody who jumped on to watch the Ynw Melly Hearing. I will post a recap for that on my page sometime, maybe later on this evening. I'll post a recap for that. In the meantime, we're going to switch over to Raul Valet, and we're going to listen to the verdict. So we were doing verdict watch on that, so we're going to switch over.